Michelle is now going to talk about the Real Estate Settlement and Procedures, the Real Estate Settlement Procedures Act, which gives us that tool of a qualified written request to try to get information and documents out of the mortgage company.
And let me remind Michelle that she's the only thing standing in the way of this large group of people and lunch.
I knew when John looked at me and looked at his watch, I knew what that meant. So what I will do, if on page 135, there's a very good chart that begins on that page that spells out the major sections of RESPA. And what I will do is I will go through them just very briefly to say what it covers, but I really want to concentrate on specifically on, there are some places I will stop, but most specifically the qualified written request. Under RESPA, the lender is required to do the following, and this is a disclosure act. There's a duty to provide the good faith estimate information booklet, to provide a servicing statement. That is, when they get the loan, they have to identify and disclose to the consumer that this is going to be serviced by someone else, if there is a servicer involved, whoever that initial servicer is. Duty to provide controlled business arrangement notice. Now, this speaks specifically to relationships. For instance, if there had been a legal relationship between the title company and the mortgage broker and or the lender, that has to be disclosed up front if those relationships exist, and there are penalties for them. And I just want to say, too, that this is a very effective act when you're looking at issues of fraud or where they have violated certain sections of this, and you can use it. I know we're talking specifically, though, about pre-foreclosure, but many of these things you still kind of have to go through to see whether or not there are any violations, because it can then help you in negotiation, even though it may not be used specifically for litigation. The duty to provide the HUD-1 settlement statement, and that, as Beth said earlier, is one of the most important documents that you're going to see with respect to these transactions. There's a duty to provide the initial escrow account statement, the prohibition against kickbacks, fee splitting, and other unearned fees, against requiring specific title services or by a specific company, charging a fee for preparing the escrow and HUD-1 statements, and the truth in lending disclosures. Those are all pre-closing disclosure requirements. Post-settlement, a duty to make timely payments out of escrow, a duty to provide annual escrow statements, a duty to perform escrow analysis, escrow surpluses, shortages, deficiencies, and now we're down to the duty to respond to the qualified written request. This one, and we've talked back and forth about this all day, but this is one of the best areas, in my view, under RESPA. And this is under the Servicer Act, which is under Section 6, where servicers are required to do specific things, among them some of the ones we've already mentioned, but they have a specific duty to respond to this thing called a qualified written request. A qualified written request is very basically a request for information. But it is, in this case, it is done in a very formal way. It is putting the lender or the servicer on notice that you are formally requesting under this section to get information. And it has, incidentally, been very effective in getting information for us. This is the document, the intention of it is to be able to get the answers to questions that the homeowner may have with respect to their loan or with the transaction in general. The qualified written request is any document that requests information from the servicer or directly to the lender. It must contain certain information. Most of it is basic, like the borrower's name and address, the reasons for the belief of the borrower that there may be some discrepancies, the loan number tied to the account, and basically any information that you are requesting in detail. Now, I have prepared a sample RESPA QWR since the penalties, if you glance back to page 137, and if you look on the penalty side of them not complying, you'll see that failure to comply can result in actual damages, cost, and attorney's fees, plus $1,000 per violation if a pattern and practice of non-compliance has been established. Because of that, and that's per violation, which means essentially if they didn't answer the questions, that one is subject to that. And so I kind of put together a 64-question letter just for that shock effect to be able to get that information for them to respond. Some of the major things that you want to ask for in the qualified written request, even though there is a sample in this which is very brief and it just has the basic information that you want to include. One thing is to determine whether or not it's an FHA loan and the number of that. One of the things that we've been having difficulty with is getting, when we ask whether or not it's an FHA loan, the servicer says, I don't know if it's an FHA loan or not, much less do they provide the FHA loan number, which begins with 441. So anytime you see a loan number that begins with 441-, you'll know automatically that it's an FHA loan. The reason that you want to, that information is important is not just the specific loss mitigation tools that are relevant to FHA loans, but you also want to know whether there's a statutory limit to the term of that loan. So, for instance, in FHA loans, it can never go 10 years beyond the original date, the original term. So you need to know that in advance so that when you're putting together a modification, you know the limit there, because we've run into circumstances where in order to meet that requirement, the homeowner may have to come up with a huge amount of dollars to be able to come within that, to make the loan affordable within, say, a 40-year period, which is extending it 10 years, but the difference has to be made up in cash. But you want to know that in advance because that's going to be important in your negotiation. You also want to know, you want to be able to get a disclosure of the actual amount owed to the penny. And the reason that it is important that you get it to the penny is that you want to be able to identify if the loan is upside down, in other words, the balance is higher than the value of the home, or it is highly inflated from the time that they took it out and it resulted from negative amortization. You want to be able to identify that amount of money because you may be able to use that as a negotiating tool to reduce the principal. If the principal has been inflated by negative amortization or other amounts that have not been used to actually fund the loan, that it's not a promise, but that may be an area that you can use to try and negotiate a principal reduction. you want to ask for the original loan documents. And now all of this you may or may not get. They may not have it. But I would use the RESPA QWR to ask every relevant question you can with respect to that loan. The original documents, loan documents, and the closing documents that Beth just went over, because those are it is through those documents that you're going to be able to see if there was any abuse or any areas that you can use to negotiate. You want to ask whether or not they do have the authority to act. Has this loan been assigned? Do they have a perfected lien? I would request inside of that QWR the name and address of the investor.
And remember, previously Patrick mentioned that they're required to give you that information under the Truth in Lending Act. So mention, pursuant to Truth in Lending Act, we'd like to have the identity of the owner of the loan. Exactly.
And I see you walking up. Okay, I'm going very fast. This little face. Okay. If there are any prior loan modifications or agreements, you want to be able to have those in hand. And you want to ask them for proof that they did notify the homeowner of a change in servicers, both with the hello and goodbye letter, depending upon who you're doing it to, lunch. But, okay, one final thing I will note, okay, that I would also CC the following entities, even though typically this letter needs to come from the homeowner or the homeowner's representative. But I would CC HUD, the United States Department of HUD. I would CC the congressperson in the district for which the property is located. The reason for that is because once a notice becomes what's called a congressional, HUD is required to respond. They must respond to that notice. And that's why it's effective if you notify the Congress. Also, if there are other allegations and there's some side-by-side complaint to, say, the Department of Banking or so, then the Pennsylvania Department of Banking, but also the relevant banking department where the corporate headquarters is. The end.
All right, thank you, Michelle. Okay, this panel, we have Beth Goodell and Patrick Cicero, and a new face, Dan Howler from Neighborhood Legal Services in Pittsburgh. Don't be fooled by the snow on Dan's roof. There's a lot of fire in his furnace. I've dealt with Dan many times over the years. So our first speaker will be Beth.
I'm just going to take a couple of minutes right at the beginning to refer to the form that housing counselors are going to be using to send referrals to legal services agencies. This is not directly relevant to those of you who are not legal services lawyers, but if you take a look at page 15 in your materials, this is the form. It's the beginning of the form. So those legal services agencies who are receiving referrals from counseling agencies should get this form first. We looked at it a little bit right at the beginning because this is the page that gets signed by the homeowner to give permission for the counselor to share information with the legal services lawyers. But if you flip to page 17 of the materials, there are 4 pages of the referral form that cover areas where a counselor might want to call in a lawyer. I mean, the legal services lawyers couldn't possibly provide service on every single situation, every single homeowner that comes into a counselor. So when should a counselor contact a lawyer, and what should the lawyers be expecting to cover in this relationship with the housing counselors. It's also just kind of a useful summary of the issues that could come up, even if you're not working with the housing counselors, a lawyer working with homeowners. It identifies 11 areas where legal concerns might arise, where a housing counselor might want to call a lawyer. It's worth looking at this. I'm not going to spend time going over every single one of these, but it's worth looking at, especially for the lawyers who are going to be receiving these referrals under this program from housing counselors. But just to run over it very quickly, item 1, lack of cooperation from the servicer or lender. Well, that heading alone could cause legal services lawyers to get referrals of every single case that a counselor gets. But the counselors are being asked to, identify a specific task that the lawyer might be able to take that would get the servicer to cooperate. And, maybe that's a qualified written request that comes from a lawyer as opposed to a counselor. Number 2, where there's been evidence of abusive servicing or dispute over the amount of arrears, and we're going to talk about servicing problems in the next panel. Assistance with loan modification, especially when there are terms in the loan modification form that's been sent to the homeowner, and it would really be useful for a lawyer to take a look at that and explain the terms to both the counselor and the homeowner. 4, pre-foreclosure and short sales. 5, executing a deed in lieu of foreclosure. If I were a counselor or a homeowner, I would want a lawyer to look at that paperwork, just to explain to me what it is I'm giving up and getting by doing a deed in lieu of foreclosure. Assessment of bankruptcy options. The money under this grant can't be used to provide bankruptcy services to a homeowner, but just analyzing the situation with bankruptcy in mind, giving advice and information about bankruptcy is a very good role for a lawyer to play. Number 7, possible predatory lending and truth in lending issues. We're going to talk about that in this panel. Number 8 really just means miscellaneous. So miscellaneous advice or information. Estate issues. Many legal services programs don't do estate issues. We don't, but we can refer to the Bar Association's low fee and pro bono program for homeowners who need estate work done before they could take the next step, either with PHFA, getting HEMAP assistance, or getting a loan modification or forbearance agreement. If the person who's come into your office is not the person whose name is on the deed. Number 10 is another miscellaneous category, and 11 being HEMAP situations. Housing counselors, you have to do a HEMAP application through a PHFA-approved housing counseling agency. So it's not as if lawyers are going to be doing those applications, but there may be questions related to the HEMAP program that a lawyer could help explain. Now I turn it over to Patrick.
Well, actually, we're going to turn it over to Dan.
To Dan, sorry.
But one comment before I do. You'll notice the referral form. The referral form, if there's one problem with it, that is that it doesn't have a space for, a borrower's phone number and a way to contact them back. And so, hopefully, for any housing counselors out there, if you could just please put it on the form, and maybe we'll try to get some communication about the necessity of that. Obviously, we'd like to call these folks back. Now, this information is supposed to be on an online program, Housing Counselor Online, that we have in legal services will have access to. And so I know that the phone number is there too, but it may be helpful for folks in the room who are, or wherever you all are, who are housing counselors, to just note that, even though there's not a space for that.
You may see a new form coming down the road, too.
It would be nice to have
this is our first, this is sort of a work in progress. This was put together in January, so there could very easily be a revised form coming out.
Okay.
For the housing counselors.
Great. Jen?
I wanted to make just a couple comments on some things that were said in the previous session. Beth was talking earlier about the yield spread premiums, and I think that's kind of shocking to see that what's happened is that the person goes in to get a loan, and the broker kind of assesses the person and then talks to the lender and said, look, I think I got a real fish on the line here. I think even though your standard rate here is 9%, we can get a higher percentage out of an APR out of this person. And as a result of that, the broker gets from the lender a yield spread premium for reeling in this person. What it underlines is the fact that the broker has no fiduciary obligation to the borrower, and that really is one of the cruxes of the problem that we've encountered, which has then spilled over into the whole economy in this problem with predatory lending. That was one comment I wanted to make. And, the other thing is, of course, if these folks had been bonded, many of them wouldn't have been in the brokerage business, and there would have been somebody to come back on when these loans started to go south, because they wouldn't take off in the first place. A couple other things. Beth mentioned being aware of the value, the real value, market value of the house before you start talking with a lender. Now, many of you, or at least in Allegheny County, we look at just to get a quick idea, we look at the county website for the real estate tax assessment, and that would vary from county to county. But the other thing is that if you're looking at some of the wealthier suburbs in the Pittsburgh area, those assessments are going to be low. But if you're looking at inner city neighborhoods where many of our clients come from, those assessments are actually high. And I have, on occasion, talked to an attorney who's looking for $60,000 because that's what he thinks he's owed. And I'll say, and this is a fellow from eastern Pennsylvania, I said, Chris, give yourself your best scenario. I go away, all right? You got a sheriff's sale, and what are you going to get for this house? He said, well, I think we got an appraisal here for $60,000. Your appraisal's no good, trust me. I mean, here's what the assessed value is, but send your own appraiser, somebody that you trust, out to look at this property. And he said, well, you got to understand something. He said, I'm not sure that my client will do that. He said, well, let me ask. So this happened a couple of years ago. So he did. He called me back. And I said, you're not going to get more than $30,000 for this house. Trust me. Call me back. He said, I can't tell you what our appraiser said, but I can tell you that it was less than $30,000. We'll do a deal for $30,000. And we did. Okay? That's one thing. The other thing is Beth mentioned about having your client start to put money aside. And it's good for two reasons. First of all, to be able to say to the lender, this is how much we've got sitting in a bank account that we can make this, kind of deal that we're talking about go. But, if you get to the litigation stage, I don't know how many times, like I'm in a foreclosure and the other side has brought a motion for summary judgment, and the judge says to me, well, how much money has your client put aside? And if I can say, Your Honor, we've got $3,000 sitting in an escrow account, the judge backs off, and the summary judgment doesn't go. All right, that's just the kind of a practical. The other side of that is that many times people come to you and they want to save their house, and it's simply not realistic. Their head tells them one thing, but their heart tells them another thing. This is where I raised my kids. This is all my memories are wrapped up in this house. And when in fact it's an albatross around their necks. And this isn't the case. We'd like to try to save the house if we can. But reality is sometimes they can't save the house. How do you get that across to them? Well, if you ask them to start putting aside a certain amount of money every month, it starts to dawn on them. Maybe I can't save this house. Maybe I ought to be looking to do something else. Okay, it makes your job easier as a counselor to, when you're trying to urge them maybe to consider the realities here. Okay? And the last comment I want to make is that in the Western District of Pennsylvania, the U.S. Attorney's Office has a mortgage foreclosure or a mortgage fraud task force. And they've been chasing some of the people who've been doing these inflated appraisals, some of the sleazy brokers, characters like that. So if you've got a case that really stinks and you're from that area, talk to the U.S. Attorney's Office or talk to the Pennsylvania Attorney General as well. Okay, well, if you turn in your materials to page 155, a counseling scenario, this is one of those cases where truth is actually stranger than fiction. This actually happened to one of my clients. Now, this came to me in litigation. This fellow was actually a husband and wife. The problem was that the wife was in a nursing home from which, unfortunately, she's not going to emerge. But he came to me with this situation. But assume that this person comes to you as a counselor, okay? Now, he's got a 9th grade education, and I wondered how he got that far. His history, his work history was as a gas station attendant and a house painter. A very compelling person, you know, just a sort of a deer caught in the headlights kind of character. And we'll call him Gus, okay? And if you look over on page 109, you'll see some of the documents that went with this case. This is the loan application. Okay, and this was a house down in McKees Rocks, Pennsylvania. Why do I point that out? Well, because that's a kind of a Blue Cross neighborhood where housing prices are depressed. Okay? Now, the lender went out, or the broker went out and got an appraisal for this house for $126,000. Boing, that set off an alarm bell right away, because I know virtually nothing in McKees Rocks is going to be worth $126,000. Now, don't forget, we're talking about western Pennsylvania, where housing prices are fairly low anyways. This isn't Washington, D.C., or the suburbs of Philadelphia, nor is it Fox Chapel, which is one of the wealthier areas in Pittsburgh. So that immediately sets off an alarm bell, okay? Well, the other thing is that when I look at this application, I see that on page 110, he's got an income of $2,833 a month. I said, where did you get that job, Gus? And I don't have that kind of a job. Well, what is your income? My income's $928 a month, Social Security. And what about your wife? Well, that's the other $1,500. That's included in that $1,500 down there. The problem with the wife's income is that it's not available because she's in a nursing home, and her income is going to pay the fees at the nursing home. Okay? Well, did the lender know this, or did the broker know this? Yes, because where did the closing take place? The closing took place in her nursing facility at the Kane Hospital outside of Pittsburgh. So they knew it, okay? All right, the other thing is that over on page 112, you'll see that the broker's fee was estimated to be $3,300. When they get to the closing, Gus did see, he was aware of this, he did see that the broker's fee was going to be $5,500, page 114. And he did raise a stink at the closing about this, and the broker said, well, I shouldn't say that. The closing attorney said, well, you can take that up with the broker later. And the broker assured him that they would work on this later. They'd take care of this problem later, okay? Now, does this kind of smell to you? I mean, this is, you know, alarm bells should be going off in your head at this time. You know, something's rotten in Denmark here. All right, so I think we've sort of covered, you can see the whole scenario is laid out on page 155. Now, this case got to me, we were in foreclosure, and the demand was for $110,000. I had an appraisal done on this house by a reputable appraiser, and the appraiser came in with a figure of $67,000. versus the broker's appraisal of $126,000. So I filed an answer to the complaint in foreclosure. And the next thing I did was I asked for the documents. Excuse me, I filed a motion for the production of documents. Well, there was a problem because a lot of the documents couldn't be found. And this is what you're going to find with many of these securitized loans. They pass through so many hands that nobody can put their hands on the documents. Just as an aside, I have a case, or had a case, involving Wells Fargo. And I filed a motion for production, and I waited 4 years for them to produce the documents. Okay. In the meantime, the good part of the story is that the client's income situation improved dramatically, and she's now in the hands of competent private counsel. But in this case, I filed an answer, and what I raised is all of these initiation problems, that there was fraud, really, in the initiation of this mortgage, this loan. The lender's attorney, representing Deutsche Bank, who was a trustee, said, well, we didn't do this. Somebody else did this. And my answer to that was, well, wait a minute. You were involved in this. This was of a piece. This was a sort of a joint venture that you folks were involved in. And these were the folks out here, these brokers were the folks that you were depending on to bring in these borrowers. And this was all part of one whole piece of cloth. And so as far as I'm concerned, you're on the hook for what happened here. Now, because of the fact that, first of all, we were litigating it, secondly, they couldn't produce all the documents, we started to get offers for, and then we started to get the reality about what the house was really worth. We went into a sort of negotiation, and the first offer I got was for $60,000. I said, my client can't afford that. Why not? Well, because the original mortgage payment, I forgot to tell you this, the original mortgage payment was for $638 a month. What does he have available? $928 a month. This won't fly. And not only that, but there was no escrow for taxes. So when you add real estate taxes to this picture, you're talking about 80% of his income is going for his housing expense? No way. Not even at 60%, not even at 50%. So the first offer was for $60,000. The next offer was for $50,000. Still won't fly. The third offer was for $40,000. And our hero, John Gorel, came into the picture at that point with a hero loan. And at $40,000, we could do this, and we saved this house with a hero loan for $40,000. And John insisted that they, PHFA, take assignment of the mortgage because they didn't want to lose position. And the lender agreed to that. That man, now this has been 2 years now, that man is still in his house. So that was one of the nice stories that came out of all of this. Now, this case had to go to litigation. But those of you who are counselors out there who see these kinds of scenarios, first of all, can start to talk turkey to the lender. And maybe you are able, without the intervention of an attorney, to talk this lender down off the ledge that he's on and get him down to a point where John can come in with one of his mortgage loan products and save this homeowner. Hey, John, did you want to add a little bit to this little scenario?
Yeah, if I could. Not in this scenario, but on a similar one. That I'm not sure if it was you and I or someone else. I forget now. But what we ended up doing was actually a combination of loans. The people had applied to HEMAP, and they really couldn't afford the first mortgage. So what we ended up doing is Hero purchased that first mortgage, recast the interest rate from, I think it was 12% down to 7.95, and then HEMAP did a small, like a $10,000 HEMAP loan, and together it worked. The numbers were sufficient to purchase that mortgage. And I just checked, actually I checked on your loan and this one on Friday, and they're both current. So it was a success story. So.
This was a man who desperately wanted to save his home and was willing to make a lot of sacrifices to do that. As a matter of fact, he called me up the other day, John, because his car is broken down and he has no money to fix his car.
We don't do car loans.
But he's making his payments because he knows that that's the first thing on his agenda is to save that house.
I think Dan's story illustrates the importance of these cases. In other words, in Dan's case, it took litigation and some help with PHFA to get to the intended result. And in some ways, that's what you're having to do. I mean, if in this crazy world that we live in, where pretty much in the mortgage world, things are up for negotiation. You know, whether it be a loan modification through a lender or some kind of partial claim from HUD or from Fannie Mae, or with the assistance of the Pennsylvania Housing Finance Agency, there are opportunities available. And in the context of this grant, in the context pre-foreclosure, I think it's really, really important to look at these documents. And one thing that I can't remember if it was mentioned or not made clear is the housing counselor should be, to the extent that you have these documents from your homeowners, sending these along with the referral form. In other words, the checklist that Beth pointed out at the beginning of this session indicate what kinds of documents we would like to see so that we can make this assessment, so that we can know if you see the settlement statement and you look at the settlement statement, in and of itself, you might not be able to pick anything out of thin air. I mean, you may be able to see that the numbers look high, because you know your area that a broker fee for $5,500 is a lot of money, particularly when perhaps you see a broker fee combined with a yield spread premium that was talked about earlier. But some of it is going to involve you talking through the documents with the client and saying, what is it that you expected? What is it that you were told that you were going to get? What is it that your understanding of the loan was? And when they frame their understanding of the loan, it's probably going to be radically different than what the documents say. My clients have not realized how horrible their loans were until after their interview with me. Like they came in to the appointment upset because they're in foreclosure, and they came out even more depressed because they had a worse loan than they thought they had. I say that in the context of pre-foreclosure. It's important for you to know that. So that you can identify them for the reasons we talked about earlier, both in terms of pointing them out to the servicer and the lender, but also in terms of pointing the client in the right direction about what it is you want to do. Beth talked about in an earlier session knowing who your client is. Is this a person that we, as legal services, are going to be able to represent in litigation because they're income eligible, and we can represent them if a foreclosure case is filed? In those cases, my advice to the client, if they have a really, really bad loan, might be a little different than for folks I can't represent. For instance, if I can represent somebody, I might say to that person, I believe you have A, B, C, and D in terms of problems with your loan. In the past, we've been able to litigate these issues and produce better results. Now, you can't, no one has a crystal ball. You can't predict the future. But in terms of giving your client advice about whether to accept the loan modification or forbearance plan that's being offered now versus the potential for something better later, you need to be able to provide them with that information. On the other hand, if they're not eligible for our services and there aren't any private lawyers or pro bono attorneys or any other services that are out there, you can give them these options, but it might be a little hollow because they might not have any way to exercise them. But it still would be good to know. I want to move a little bit into truth in lending, but before I do that, I didn't know if either Dan or Beth had any more comments about kind of general aspects of predatory loans. Okay. It's important for you to look at these loans to see if there's a truth in lending violation. Programs, legal aid programs might do this differently. This can be a quite cumbersome analysis sometimes. But I want to, if you look at page 123, that's the sample truth in lending statement that is in the materials. And I want to point out what it is that some of the basic things that you can do to look at this, to make sure that truth in lending has been followed. And let me just back up one step. Here's why it's important. Because if you can find a violation of the Truth in Lending Act, particularly that the material disclosures weren't given, such that this Truth in Lending disclosure is inaccurate in some way, and or the notice of right to cancel that Beth pointed out earlier that is on the page following the Truth in Lending statement wasn't properly completed, or the correct number of them weren't given, because each homeowner, not each borrower, but each homeowner is entitled to 2 copies, one they keep, one they turn in if they elect to cancel the loan. And so if there was some fundamental problem with the disclosures, and this was a refinance loan, not a purchase money loan, and you're within 3 years of the date of the refinancing, you can actually cancel the loan at that point. The Truth in Lending Act, under those circumstances, allows for rescission, and generally speaking, if you look at the following page 125, the actual document itself, this notice of right to cancel, gives you 3 days to cancel the loan. And in a refinancing transaction, the lender doesn't even fund the loan. They don't even lay out the money until this, supposedly, hopefully, until this 3-day right to cancel expires, and that's when the loan gets funded. And so you have 3 days to change your mind for any reason or no reason, and that's why getting this is important for any homeowner who elects to refinance. And so if a homeowner, I don't know, I guess it's theoretically possible that someone could come in within 3 days, but it seems unlikely. But if a homeowner decided that within 3 days they didn't want this mortgage, they'd cancel the loan, it would never be funded, they would go back to the status quo prior to the refinancing. But that typically doesn't happen. And so let's say you get a homeowner who comes into your office as a counselor and or into the legal aid office or other office that you work for, and it's been within 3 years. It was a 2007 loan, now it's 2009. And one of these disclosures wasn't made. They didn't get the notice of right to cancel, or they got the notice of right to cancel, but they only got 1 copy of it, or it wasn't filled in properly. Something to that effect. The law allows you to rescind the loan at that point, to cancel the loan at that point, so long as it's within 3 years. And there's a whole bunch of complicated. It's quite complicated to go into what the effect of a truth in lending rescission will be, but quite simply, the lender is supposed to honor that rescission and cancel the security agreement, meaning they shouldn't proceed with the foreclosure. And if they do that, then there's an obligation on the homeowner's part to do what's called a tender, basically give back the quantum merit value of what they received, not counting all fees and interest, all of that being applied to the principal balance, all payments being applied to the principal balance. And so that, often lenders say, well, how's your client going to tender? I mean, if you have a valid rescission claim, the immediate response from many lenders is, how's your client going to tender? And you should, if you enter into one of these transactions, if you actually do have a loan that is in fact rescindable, you're going to want to think through that, although, to be honest, there's a variety of ways that you could tender, including, having another loan come in, and maybe it's a loan like a HERO loan, or some other opportunity or option. But I mentioned this to say that this can be a very powerful thing. Truth in lending is extremely complicated, and so I don't want to spend a whole lot of time talking about the nuances of rescission and or tender. But if you get a loan that you believe is rescindable and you don't feel like within your program you have some of the expertise to talk it through, I know that folks at Community Legal Services are available. Dan or I would be able to help talk it through too. We are one big legal aid office here in Pennsylvania.
I want to say just a little bit more. We made a decision not to try to cover truth in lending math here because of how difficult it is. and since making that decision, I've seen 3 cases, as I mentioned earlier, that I believe can be rescinded under the Truth in Lending Act, and I just haven't been seeing that many recently. So it occurred to me that I should at least share the scenarios in those 3 cases, because it might come up. One is that, as I mentioned earlier, the Truth in Lending notice of right to cancel has to be given to every owner of the property who is a resident of the property.
As opposed to borrower.
As opposed to the borrower. And I saw a case where the wife of a couple was not the borrower on the loan. Her husband alone was on the note, I assume because she didn't have much of a credit history. The loan was made to him, but they owned the house together as entirety's property. The Truth in Lending, so she wasn't on the note. Her name wasn't even on the mortgage, the blank mortgage form that she'd been given at the closing. She did tell me that she'd attended the closing and had signed some papers, but she didn't have copies of papers with signatures. So we went to the publicly recorded mortgage, and her name had been added to the mortgage, had been typed in a different typeface so that she signed the mortgage. So they did have a valid mortgage. But the Truth in Lending notice of right to cancel that had been given to her only had her husband's name on it because he wasn't anticipated as one of the borrowers. So she can cancel this loan. And the situation is that the husband has now moved out and she's left alone in the house. But I think we can turn this into a situation where she gets to keep the house at a significantly reduced debt because we get to strip out, as Patrick said, all of the fees, and you get to credit all of the payments that have been made on the loan to the principal balance. So you get to reduce the debt significantly, and we're going to press for a loan modification in that case at the significantly reduced debt amount and a reduced interest rate. Now, are we going to be able to pull this off before foreclosure is filed? I don't think so, but we're going to make the request. We're going to send a notice of cancellation, which has to be done in writing. You should send it to the current servicer as well as the owner of the loan if you can identify the owner of the loan. And we'll see if they're willing to do that before they start litigation. And if not, this is somebody we'd represent in the foreclosure with a very good defense to the foreclosure. The other 2 cases didn't involve an error like that in the notice of right to cancel, but rather in the numbers. If you look at the Truth in Lending disclosures on page 123, and by the way, the E's on this notice in the 4 blocks at the top where it says annual percentage rate 9.466 with E, that means this was an estimated. This was a Truth in Lending statement that was given before the closing, and the E means it's not the final numbers. So there would be another version in this loan transaction that had the final numbers. Errors that are based on the numbers have to do with an error usually that the lender made in classifying some of the upfront fees. If you look at a HUD-1, a settlement statement, there are always fees in it that count as finance charge. The application fee, the broker fee, and miscellaneous other fees count as finance charge. And when the lender calculates the amount financed and the finance charge that are disclosed, those fees can't be included in the amount financed. They have to be included in the finance charge. If they get it wrong, if they have classified some of the fees as amount financed when they should be finance charge, then you might catch them in an error that's large enough to give you the right to rescind the loan. And this is the piece that we decided not to go into in any great detail because it's a little numbing. But the error that I saw recently was that the mortgage company had 2 charges related to the title insurance and the title search. In Pennsylvania, I go into this because this is an error that may be made often, relatively often. The Insurance Rating Bureau sets out the title insurance rates, and there's one fee that fits for a loan depending on the size of the loan. That fee should include the work that it did to examine the title as well as issuing the insurance policy. On this HUD-1 for this other loan that I have in mind, there was a fee for the insurance and then there was a separate fee for a title search. It was a couple $100. And I know that you can't charge additionally to the the title insurance fee, a separate fee for doing the title search. To rescind under the Truth in Lending Act based on this kind of mathematical error, if the loan is in foreclosure, if a foreclosure has been filed, an error of $35.01 can give you the right to rescind. So it's actually easier to rescind with a Truth in Lending Act mathematical error after a complaint has been filed. So, and as Patrick said, we're not trying to teach you today how to do this analysis, but if you see something like this, a fee that is related to the title insurance that's apart from the insurance fee itself, contact somebody who knows how to do a Truth in Lending analysis. You may have a case that if it's in foreclosure, you could actually do a better job for your client with a Truth in Lending rescission than you can before foreclosure.
Yeah, I had a case where the appraisal fee was way out of line for the area that we were talking about. And I had consulted somebody who did appraisal work in order to ascertain that. And that was enough to tip this loan into a Truth in Lending violation. And that was a case where actually it tipped it into what's called a HOPA violation, Homeowners Equity Protection Act violation, which is part of Truth in Lending. And we don't see many of those anymore because the lenders have gotten smart enough to come in right under the wire. So we won't get in it. But anyways, the essence of my point is that if you see, and to pick up on Beth's point, if you see a fee that looks really out of line, like an appraisal fee that just seems to be out of line, that may be something that would tip this into a violation of the Truth in Lending Act, which then gives you other rights of rescission and also some statutory damages. So you might want to talk to an attorney who does some Truth in Lending work if you see that kind of a situation.
I have one more example that's based on the notice of right to cancel. Very quickly, the client, the loan closed at her office. And well, she was at her office. The settlement agent was at the home that she shares with her parents, getting her parents to sign the loan documents. He faxed her the documents. He went back to his office, faxed her the documents to her office, had her sign them, fax them back to him, and mail the originals. So she didn't get a copy of her right to cancel that she could keep. The notice of right to cancel has to come in 2 copies, one that the homeowner could presumably use to cancel, send it in to cancel, and one to keep. So she didn't get either copy for herself because the lender instructed her, the closing agent instructed her to mail the whole thing back to him, having signed and faxed it. So in their records, they would have a copy of this document that she signed, but in fact, she didn't get one that she could keep. So look for oddities like that in the delivery of these Truth in Lending, both the disclosures and the notice of right to cancel.
And it's important to note that if you, in the pre-foreclosure stage, spot something that you can rescind the loan for, that, writing a rescission letter would fall within the confines of this grant. I mean, that's not litigation. Now, that's going to provoke litigation. I mean, it's likely that, as Beth said, that it's unlikely that the lender is going to necessarily just up and honor that, and you're going to be able to have a negotiation that's going to produce some tangible result. And so you may want to think through the ramifications of doing that for an above income level borrower for your ordinary income guidelines if you're in legal services, because it's you may not be able to carry that client through. Or you may want to get involved if I know in Philadelphia and in Pittsburgh they have a much more active, pro bono bar that they can turn into pro bono and then fee generating cases. I mean, if you can work with a private lawyer on these kinds of cases and help them through this, or on their own, rescind the case pre-litigation, that can be a very good and powerful thing. But rescinding a loan would be appropriate and permissible under the parameters of this grant. I want to point a couple of other things on the Truth in Lending statement, just so you know about them, and they really have to deal with what Beth was talking about in the previous session. If you look at the statement on page 123, and you look at the box where it says the payment schedule will be, and there are three payments here. There's the first 24 months, there's 335 monthly payments, and there's one monthly payment. And then if you look down, and well, first of all, if you see the first 24 months, the monthly payment for principal and interest is $601.01. And that's calculated based on the interest rate that's stated in the note over this 30-year period of time. And that's the first 2 years. And then this is an adjustable rate loan. And so after 2 years is when the interest rate is going to adjust. And when Beth read the note to you, you saw that, and I'm not even sure if this note is if this truth in lending statement is for that note. But the note will say that it adjusts after 2 years, and there's a first adjustment, and then it could adjust every 6 months after that. That's typically what they do. You'll see that they don't have 6-month adjustments. It's not like they write this out. They assume that first adjustment carries out through 335 months, almost through the rest of the loan. And that assumption is based on a couple of things. The first thing it's based on is if you go down to the middle of the page where it says there's variable rate, it says there's a variable rate feature on this loan. And then in the box below that, they say the current index used for this calculation is 3.010%. That's the index, that's the LIBOR or whatever it was at the time that the truth in lending disclosure was written. And so that's what they add to the base amount, the 6.05%. And so when they made that assessment, that 335 payments, the second block of 335 payments would be $649.18. They did that based on a index of 3.010% plus whatever it is that they add to that, 6%, 5%, whatever the case may be. That assumes at the time that the loan was originated that the world stays the way the world is. And we know that LIBOR goes up and LIBOR goes down. And so I say all that to illustrate that truth in lending is supposed to be a disclosure statute. In the context of ARMs, particularly subprime ARMs that are, well, all ARMs, particularly subprime ARMs, they don't really work very well to accurately predict what people's payments are going to be. And that's because I've had clients come into my office and say, well, they told me my payment was going to be $649 after the first 2 years, and it wasn't that. It was $800. And when you show them what the note actually says and what the change of the interest rate change portion of the note, and you explain to them how the mortgage company calculated their interest rate now, the first question always is, why didn't they tell me it could go that high? And so I point all this out to say what folks at closing are going to be shown, because they're not going to be explained the nuances of the note. They're going to be shown the truth in lending statement. And they're going to be shown that this is your monthly payment, and after 2 years it's going to be about that. And all of that, even if you don't have a truth in lending violation, even if the math works out and they were given 2 notices of the right to cancel, if the facts and circumstances of the closing are such that it wasn't adequately explained to them or was explained to them in an unclear manner, it very well may create a violation of Pennsylvania's consumer protection law. That a UDAP violation such that there are claims you can bring, even if the math is all correct here. So just looking at the truth in lending statement is very, very important in understanding the client's story and understanding why they believed that the payments could only go up to $650 a month. I can afford it. It's only $50 a month more. I could afford that. I thought that that's what it was going to be. And so I've had many, many clients come into my office and tell me that. They get payment shock because that's not what it is, because this document doesn't accurately reflect the way the world's going to work when this adjusts. And I'm not sure any document could. No document could predict what the LIBOR would be, but it just shows you how pernicious these loans actually are. And so, again, we're not dealing with litigation, but if you ever get into litigation on these cases and this thing gets to a motion for summary judgment or you get to argue before a judge, explaining to the court, how the disclosures that were given that were supposed to be disclosures that helped your client understand what the cost of the loan were, pointing out the internal constraints of them and the problems associated with them is helpful in presenting to the court how unfair this loan may be. And it may, although I don't know, may be helpful in explaining to the mortgage servicer the reason why, because every mortgage servicer is going to want a narrative about why you fell behind. And the reason why you fell behind may be because it wasn't appropriately explained to you. You might not get much sympathy from the mortgage servicer, but I think it's important to look at the truth in lending statements for that reason too, not just a complicated, like if you're worried about being bad at math. I know Don Meritz once told me that he's innumerate, that he's and so if you're worried about truth in lending and you're bad at math, I mean, looking at the truth in lending statement is still pretty important. One final thing about rescission, knowing the facts of your client's loan is very important, because knowing where the loan closed, if the loan closed in your client's house, which many, many loans do, or if your client was solicited at their house by telephone or personal visits or whatever the case may be for a refinance, you may very well have the ability to rescind that loan under Pennsylvania's Door-to-Door Sales Act, which is a part of the Consumer Protection Law. And that law says that if the disclosures, which are similar to truth in lending disclosures, aren't given, that you have an unlimited amount of time to rescind that loan until or unless the disclosures are actually given. So it could be a 5-year-old loan, and so the truth in lending rescission period is passed. But if the facts and circumstances suggest that this was a loan closed at their house, or the contract was negotiated at the house, or was solicited at their house, you might want to take a look at whether or not the provisions of Pennsylvania's UDAP law, which relate to door-to-door sales, actually apply as a way to actually rescind the loan or cancel the loan too.
We're into the final session on the agenda, and this will take us at least till about 4 o'clock. We have a bunch of questions from different people that we want to get to, and I think what we will do is hold till the questions till then. And if there are any questions from any of the remote sites, please send them in so that we'll have them available. But I think we'll jump right into this session now. And Patrick, are you the person to start?
I suppose so, and I had a request for me to pull the microphone up, so I will do that. Hopefully not too close. This session deals with abusive servicing, and a little bit, we were talking a lot about origination problems and disclosure problems at the outset of a loan, such that the truth in lending disclosures weren't made properly, or the facts and circumstances behind the clients, the origination of the loan may have been problematic, and that might lead to some potential leverage that you have with the servicer in trying to work out some way to avoid foreclosure. And so we want to spend some time now talking about the other way these cases might present themselves. And servicing problems, for every person who got a predatory loan, a bad loan, they also probably got a not so great servicer. As Mike pointed out at the beginning, the servicer is the person who collects money. They collect money, they apply, they hold your escrow account and pay taxes and allocate the money to escrow and principal and interest. They also then send monthly, or not sure how frequently, the interest money or payments off to the investor so that the investor gets paid, whether that's Fannie Mae or Freddie Mac or a securitized trust. That money gets sent to a trustee. And so the servicer, though, is the entity with which your client has the most contact. And so because the servicer is who your client has the most contact with, they're the person that your client's going to identify as the mortgage company, and they're also the person who your client is going to see as the face of the mortgage, the person who quotes them payoff quotes, the person who quotes them reinstatement quotes if they're behind, or the entity that sends them letters, if they get they miss some payments, delinquency letters, or issues the Act 91 notice, or things of that nature. And so your client is going to have significant contact with the servicer. And these servicing problems can come in a variety of forms and a variety of contexts. I want to give two examples. There are post-bankruptcy servicing problems in bankruptcy, post-default notice servicing problems, and then just kind of normal servicing problems. And I don't want to spend any time at all talking about the servicing nuances of a case in bankruptcy itself, because we can't do bankruptcy, but I want to spend some time talking about servicing problems that might occur post-bankruptcy. So it kind of relates to maybe some servicing issues in bankruptcy, because you're going to get clients who come in post-bankruptcy, and those are clients who we can help and handle cases for under this grant. And so let me set the stage post-bankruptcy. And Mike's up here to clarify everything I've said.
Well, and thank you for that opportunity, Patrick. One of the things that servicers do on a monthly basis, they must pay to that first level investor the principal and interest that's due that month. Each and every month the servicer pays it. So that's even if the loan is in default. And if you think about that, that's the reason why servicers like foreclosures to take as least amount of time as possible. Because each and every month, they're not only paying that principal and interest, they're also paying the taxes and insurance in many cases. And of course, they have to advance those funds on behalf of either the homeowner or the investor. So that's an important thing to keep in mind. It's one of the many challenges that servicers deal with in dealing with loans in default.
And that's why it's really hard to get a servicer to slow down the pre-foreclosure process. And so stepping back a bit, sending in a qualified written request that's legitimate, that legitimately questions some of this stuff, will get them to slow down this process. But servicers have every incentive in the world to get these files to Mike's office or foreclosure attorney's offices so that a foreclosure can be initiated, because that's when they can stop sending in those monthly payments to the investor. So post-bankruptcy, I had a client come into my office, and I want to tell this by way of anecdote. I had a client who came into my office who successfully, or so they thought, completed a Chapter 13 bankruptcy plan. There was a 3-year Chapter 13 bankruptcy plan. They actually got a Chapter 13 discharge. And the bankruptcy wasn't filed by legal services, it was filed by a private attorney. And it was successful. They paid back their arrearages. And then 3 months later, after they got out of bankruptcy, they got a notice saying they were behind. They had made all of their payments since the bankruptcy discharge was entered, and they couldn't, for any reason whatsoever, understand or figure out why it is that they were behind.
If you look at page 157 in your materials, there's a sample of such a notice. It's not from Patrick's case, but it's from a case of mine that was the same situation. It's the front page of an Act 6, Act 91 notice, and Dan is going to talk about those laws. But just so you have a point of reference, it asks for fees and costs of $4,700, and it turned out that those fees were related to a bankruptcy that had been successfully completed, and right after that they're getting collection letters for an enormous amount of money that they didn't really owe.
And this is where it shows up. It shows up as other default expenses and fees. And so, my clients had no idea what this was about. And later on in the materials, there's a nice letter that Beth wrote, I think related to this case, that kind of details all of her investigations about this particular client under these particular facts. But in my case, he was behind $2,700, and he didn't have $2,700. They had leveraged themselves tremendously to try to complete this bankruptcy plan. They were able to now remain current, and even since the filing of the bankruptcy, the last 6 months or so of the bankruptcy, they kind of limped through because my client's spouse had lost her job. She had lost her income. And they knew that they only had 6 months to pay. They struggled. They paid it. They got the discharge. They thought they were going to be back on track in making their mortgage payments. And they get this notice saying, hey, we want another $2,700 from you. What turns out happened is that in the course of their bankruptcy case, there were various times where they were late on some payments. And on their regular monthly mortgage payments outside of the plan. They made them, but they were late. And late fees were added to their account. And so that, in terms of their late fees, they were like $72 a month. And I calculated there were about 10 months in this 3-month period where their payment was late under the terms of the note. And so there was $702 that were added to just kind of put in what's called suspense. If any of you had the pleasure of reading a mortgage payment history, you know that there's all kinds of numbers and columns and graphs and hieroglyphics and of other, all kind of unintelligible information. And one of those columns is this column called suspense, which is basically where servicers can park money until they allocate it out, right? Until they allocate it to, especially if they get a lump sum. If they get $2,500 for a bunch of different payments, they put it in suspense, and then they dole it out from there to apply it to interest, principal, escrow, fees, et cetera. And there's nothing per se inappropriate with them putting money in suspense and then doling it out consistent with the terms of the note and mortgage. And so what had happened is suspense can carry both positive balances because, you can accrue positive amounts of money in there before the mortgage company doles it out, or negative balances, meaning monies that you owe, at least from the mortgage company's perspective, to the mortgage company. And so he was building up this negative suspense balance of $702. And the other thing that comprised this $2,700 were that there were on two occasions where the mortgage company had to file motions for relief from stay, meaning that they believed, because his payments were late on these various times, that they filed a motion for relief from stay with the bankruptcy court, and they wanted to be able to proceed with foreclosure. Ultimately, the homeowner's attorney in bankruptcy was able to enter into a stipulation or an agreement with the bankruptcy, with the mortgage company and through the attorney to cure those breaches. And those stipulations provided for attorney's fees to be paid to the lender's attorney. And the stipulated amount of those attorney's fees was $500. But there was also, the lender added attorney's fees, other attorney's fees, that I don't know, I still don't really know what happened, whether or not their attorney billed them, and the company didn't get the money back, or whether or not the mortgage company made it up out of whole cloth. But they were identified on the mortgage payment history as attorney's fees for relief from stay. And instead of being $500, which would have been paid back through the stipulation, they were $750. And so that was another $500 of this. And so $250 of the attorney's fees weren't paid back by way of the stipulation in any accounting that took place in the context of a bankruptcy. And there was another $500 that were added. There were also fees that were added to make up this $2,700 for the preparation of documents in bankruptcy. The mortgage company added a proof of claim fee. Proof of claim is the thing that was filed with the mortgage company saying how much the arrears are. They didn't account for it in the proof of claim, that this is how much you owe us. They just charged the fee and assessed it into the borrower. And so all of that, my client had no idea about. They thought they were getting out of bankruptcy and they were going to be, this way they were going to get off scot-free. And so there were a couple of options that we had. One option would be if we could go back to the bankruptcy court. I looked at the bankruptcy transcript. I tried to talk the bankruptcy attorney who handled this case back to getting this client back and handling this matter, but she declined to do so. And so because this client was facing foreclosure, basically through, in my opinion, no fault of their own necessarily, we decided to take on this case and figure out what the servicing problem was. Because we couldn't account for it. We didn't know any of this up front. I filed a qualified written request and got this information from the mortgage company. And when I got this information from the mortgage company, their position was that all of these fees were appropriate. They didn't hide it. This was not a game of we're going to hide the ball. We're going to try to obscure where this is. It wasn't made clear. Like Beth's Act 6 notice, it didn't spell it out on the default notice that my client received. But when I got the mortgage history, they didn't hide it, and in fact, they wrote a very nice letter detailing how they arrived at that figure. And so my opinion was that none of these fees were earned or appropriate because none of these fees were requested by and then through the bankruptcy court. That it was my opinion that I know Mike, I know. And
I've got it.
and
I'll wait till you're done.
And there's a nice dispute about whether or not they have to be. So we, in my client's case, we were able to convince the servicer without the threat of going back into bankruptcy court and or filing a claim in county court that if my client's current, this is $2,700 we talk about, given the current climate that we live in, we were able to convince the servicer without going into any litigation. And the reason I'm using this example is because this is an example of a case that we settled without any litigation. Without going into any litigation, we were able to convince the servicer that they would actually finally waive and get rid of these fees. That they would, since my client was current, since they didn't really, so they now say they didn't really want to take this case into foreclosure, or they wanted to work with my client. We were able to convince them to take it off. Now, since that time, I have asked my client to request another payment history, just to make sure that that figure isn't still floating around out there, because some of the problems that have happened in the past were that that this might come up when they request a payoff statement. You know, it may still get kind of snuck back in there when they request a payoff statement. And my client hasn't gotten back to me, so I'm not sure whether or not the information was finally removed. And before I let Mike comment, which I will do so about that, I want to point out something in your materials, and that is on page 177, that deals with some of this information. It's a bankruptcy case called In Re Stewart. It's a bankruptcy decision out of the Eastern District of Louisiana. And it's a case involving Wells Fargo. This is a case by Judge Magner. The whole opinion is not reported here, so don't try to read like the 5 pages here and think something's wrong, this doesn't make sense, because it won't make sense if you like try to read. It's like a 35-page opinion. But the relevant excerpts are reported here, and the site is here. 391 BR 327. It's an April 2008 bankruptcy opinion. And in this case, what happened is something substantially similar or analogous to what happened in my case, where Wells Fargo, a bunch of different proofs of claim were filed, different fees were added on and not accounted for in those proofs of claim. In this case, Wells Fargo went through about 4 different bankruptcy attorneys, and so there was some discrepancy about the attorney's fees that were or were not reportable on a client's loan. And there's these patently inconsistent inconsistencies between the proof of claim amounts and the loan histories that the client requested in the context of a bankruptcy. And in that case, what the judge found was that these things weren't reconciled. And in this case, she actually found in favor of the homeowner in somewhere in the neighborhood of $10,000 in damages plus lawyer's fees, and ordered district-wide, kind of reassessment of Wells Fargo's practices in the Eastern District of Louisiana. And so this is a good case for you to read. I can say that as it relates to, and maybe this is what Mike's going to bring up, but as it relates to whether or not you have to go back to the bankruptcy court every time you want to impose a fee on a loan history, the Middle District of Pennsylvania at least takes a different view than the Eastern District of Louisiana. And so their view is that they need not ask for leave all the time. Judge France has an opinion. It's Judge France, right? Yeah, has an opinion that says that that's not a requirement under the bankruptcy code. And so to the extent that you are litigating these cases in the Middle District of Pennsylvania, some of the relief that may be available, such as in the Eastern District of Louisiana, isn't going to be available for you. Although the same principles might apply. If these, I'm going to get into in a little bit why some of these fees may or may not be authorized and why some of this servicing is problematic in any event, independent perhaps of the bankruptcy code. But in the Middle District of Pennsylvania, it's a little bit of a different world, and I don't know if you want to comment on that.
Well, that is part of what I'd like to talk about. One is, and Patrick mentioned this about ordering a payment history and reviewing that. An educated borrower is one who would be doing that on a regular basis with any lender that they have to make sure that whatever annual or semi-annual or monthly statement that they get is accurate, and to raise the issues as they occur. And unfortunately what happens is it's generally not that two-way street with the borrowers. It's not until a problem arises is when questions are raised about the account. And it is an ongoing relationship between the lender and their homeowner borrowers. So I would caution anyone to make sure that what you get from your lender is true and accurately reflects what's due and owing. The other issue is the issue of what's a reasonable fee and cost in a bankruptcy or foreclosure matter, and how do you ascertain that. The amount, generally lenders charge or are charged about $100 to prepare and file a proof of claim in a bankruptcy proceeding. They're charged that by their attorney. That's been the fee for about the last 10 or 15 years. If the level of transparency and disclosure that is required in some of the bankruptcy court decisions that have come out, and that's been pushed by the United States Trustee's Office and the Chapter 13 trustees, is implemented, you well could see that amount be more in the neighborhood of $500 or $600. And the question is it pre-petition or post-petition bankruptcy, and who is authorized to incur it and who is authorized to charge it? Does the bankruptcy court want to see a fee application from the creditor's attorney on each and every incurred cost? And that would have a large impact on the court's jurisdiction and its ability to handle cases. And it's not just in the proof of claim. It's also in any motion for relief or motion to dismiss. The level of transparency, I'm not saying it's not necessary. I'm saying that there is has been a weighing between the amount of transparency versus the cost to provide that to the underlying consumer. And as Patrick indicated, this isn't a case where the lenders are just throwing things in there that they're making up out of whole cloth. That's not my experience. They can point to specific expenditures in the account history that they believe that homeowner is responsible for. You look in bankruptcy, there's 220 different districts and divisions that, and not each, but there are variations in how everyone reviews what's permissible under the bankruptcy code, under the mortgage documents, under state law, and under federal law. And you multiply that across the country, and you can see the complexity that servicers are faced with. Again, it's not to excuse the lack of good, solid, transparent information to the homeowner, but I think we have to understand that if a bank files a motion for relief and is successful in getting that relief, what if they then had to go in and file a fee application? And of course, they have to include in that the additional fees necessary for the fee application. And you could see a motion for relief, which normally is in the $300 to $500, $600 range, could be a $2,000 or $3,000 item that the homeowner has to pay for. So we have to be understanding of that, because you have to be careful about where that eventually leads to. So,
yeah, sure, go ahead, Dan.
In the Western District, we had a rather infamous case where somebody, wasn't one of our cases, but where somebody completed successfully a Chapter 13, thinking that after all this effort, after 5 years of effort, they had saved their house, they had cured the default, and come out, and only to be hit with what's called an Act 6 notice, which we're going to talk about, saying that they were in default. And what it went back to was that during the course of the bankruptcy, certain fees had increased. However, the homeowner was not informed of that. Now, in this infamous case, the lender then produced, or the servicer produced, quote-unquote, letters saying that they informed the trustee and the homeowner and the homeowner's attorney. Unfortunately, the letter to the homeowner's attorney was written to the new address before they had moved to the new address. And so the judge's eyebrows went up about 5 inches with that. But in the Western District, you as a lender, you have to alert the court, alert the trustee, alert the homeowner and the homeowner's attorney that your fees, that the escrow account has gone up or some other fee is raised, so that they can adjust the plan, so that when they come out of the bankruptcy, they indeed have a fresh start and they have resolved all the issues. Okay? So my point is to you who are doing the counseling, if you see a case where you've got somebody, as Patrick had or as we had in the Western District, where somebody comes in, they think, I just got my discharge from bankruptcy and now I'm back in foreclosure again and I've made all my payments, something's the matter, okay? And you need to refer that person to an attorney very quickly so that they can handle this problem. Okay, that's just the point.
Yeah, and the problem really is, and I agree with Mike in the sense that there's no doubt that if the courts require the appropriate measure of disclosure, that the attorneys preparing proofs of claim in most releases are going to increase their fees. The problem, of course, is those fees are already being incurred by our clients. They're just being incurred from our perspective off the books in terms of whether or not they're being incurred in the context of a bankruptcy. So it's not like the $100 proof of claim fee isn't being paid by our clients. It may not be included in the proof of claim. It's just added to their account history. And so that's why it's a problem in terms of, the disclosure is important so that a borrower can know what it is that he or she has to pay to reasonably complete a Chapter 13 plan. And we've found that the problem is that folks, there's such a low success rate for 13s anyway. Those folks who do complete them and then get socked by some of these extra fees, it feels like a double whammy. And so what I'm suggesting is that if, because a failed bankruptcy, whether it's a dismissal that results in another foreclosure that might be coming down the pipeline but not yet have been filed, or a successfully completed plan could come into your offices under the context of this grant, you could be seeing servicing problems. And the other issue is, and I don't think I'm wrong about this, is that mortgage companies don't really have a great way of tracking post-petition, pre-petition payments. And so when you're in a Chapter 13 bankruptcy and you're making your payments, you're making your payments to the trustee and you're making your payments on your payments outside the plan, the software for mortgage servicers isn't great at allocating all that money properly allocating the money that's coming in from the trustee, properly allocating the money that's coming in from the mortgagor, and so that could produce significant problems in terms of where this money is being sent. And it could be an innocent mistake. In other words, it could be if you figure this out and the servicer say, oh yeah, we're wrong, we didn't allocate that properly, it could fix the problem.
Well, yes, I think the allocation is correct. I think the explanation may not be readily available to the homeowner through that particular loan person that you're speaking to at the mortgage company. But it is allocated. The one issue that happens often in bankruptcy, not often, but it does happen in bankruptcy, is whatever the payment is that comes in, is it properly noted as either a pre-petition payment under the plan, or is it a post-petition payment that's a requirement for the homeowner or the trustee to make on an ongoing basis. And that's just a classification issue, although it's immediately applied to the account and applied to one of those two tracks. It may not have been the one that it was intended to by the payee. But I think overall the issue that Patrick raises and that Beth's example shows as well is that there is room for discussion and for, get the information, clarify it, and work from that point of negotiation forward. part of the reason I do this is to dispel the myth that lenders are out there just junking the accounts up with all sorts of things that haven't been reasonably and actually incurred. We can argue about reasonability, but actually incurred, I think, is proven in most of these cases, in the large majority of these cases, and it becomes a point to negotiate. And certainly, homeowners should be given the opportunity to propose something based on a full disclosure of all the information. The systems may not be perfect so that demand letter has the breakdown that everybody wants, but it is available if you ask for it.
Okay. The two other scenarios that I want to talk about is a post, rather than a bankruptcy, just a post-default scenario. If your client gets a notice of default, I had a client in Lebanon County where they received an Act 91 notice, said that they were $2,714 behind. And it was in this time 2 years ago, in 2007. So it was March or April 2007. It was tax time. They had gotten a large income tax refund, and they got the notice that said they were $2,714 behind. They got their tax refund, called the servicer up and said, how much do I owe now? And they gave them some other number that was a little bit higher than that number. And they paid the amount. They had a certified check made payable to the servicer in the amount that they were told over the telephone that they should have paid. They sent it off to the address that they were told over the telephone. They luckily made a photocopy of the check before they did that to show that where the check was and where it was sent. And the servicer acknowledges having received that, but then they received it and applied it. But 2 months later, what happened is instead of my client getting a bill, which they were told they were going to get, they were told by the servicer that you'll get another monthly bill in the mail and you'll start making your monthly payments again. They got a complaint in mortgage foreclosure. And they couldn't, and that's what drew them into our office. And they couldn't figure out how in the world they would have gotten a complaint in mortgage foreclosure when this happened. And so what we did was, I called up, and this is another, again, pitch for if you can, if you know who the lawyer is representing that mortgage company, and again, it's a little bit more difficult in the context of pre-foreclosure, it can be helpful. Because I called up the attorney representing the mortgage company and said, hey, here's the problem. Can you, give us an extension of time, kind of place a hold on your file while we figure out what's going on with the mortgage company so that we don't rack up more fees and costs and so that that doesn't happen. They said, sure. We sent a qualified written request in and got the information. And what happened is that in this case it was Wells Fargo. Wells Fargo put the money in suspense. And then they drew it down in the completely reverse order that the note told them they were supposed to draw it down. In other words, if you read the note says that you pay interest and then principal and then escrow and then other fees. And that's the contract between the parties, right? That's the application of payment provision of the note says how the money should be applied. And what they did, instead of paying interest, principal, escrow, other fees, which would include legal fees and late fees, et cetera, is they paid legal fees, late fees, then they paid escrow, and then they paid interest, and then finally they paid principal. But when they drew all that money down, they had added, but the mortgage company says, well, it doesn't matter how we do it. Either way, it should come out right, because if they owe $3,700, we can apply it however we want. They owe $3,700. The problem, of course, is that they added a fee for preparing the complaint that was sent in the interim. In other words, the clients had sent in this money, and they got crossed in the mail, even though the payment history shows that the money arrived before the file was sent to the mortgage company's attorneys. They added a $1,250 fee that they paid to their attorneys for the initial filing of a foreclosure and all the associated events that surround that. And they credited the money to that first and then to all these other things. And so they were still $1,250 short on their payments. And that's what then, so basically the foreclosure drove the foreclosure. And that was a case that for reasons that are beyond me, the mortgage company wouldn't budge on. They believed that this was appropriate, this was good, this was fine, and so they pressed forward until I was able to, bend the ear a little bit of the attorney representing the the mortgage company, and they finally, because we filed an answer, we spelled out what happened, we attached the loan payment history, attached the note that says how you're supposed to apply the payments, and then, finally, after we were about 6 months into litigation, I couldn't understand why it took this long. They said, okay, because my clients were able to afford this, and they started escrowing payments with our office that were equal to their mortgage payments. And so I kept telling the mortgage company, we have your money that we can give you. There wasn't a problem with this loan. It wasn't a bad loan. It had a 6.5% interest rate fixed. But they wouldn't budge. This is somewhat of an anomalous story, I know that. But it was only after we got to the point where the mortgage company's attorney said, they want me to file a motion for summary judgment on this. And I said, okay. And he said, look, I'm going to try to talk to them again. And finally, they budged. And what they ended up doing is acknowledging that they were wrong in the first place and going back and undoing everything. And I don't know what the internal workings were or the conversation was from the mortgage company's attorney to the mortgage company or within the Wells Fargo itself. But it's another example of servicing problems where this was just a misallocation of payments that should have never happened in the first place and should be. Those things should, if you have an example like that, should hopefully work themselves out a little more fluidly than mine did.
I have a question for you, Patrick.
Sure, Beth.
And in a few minutes, Dan is going to run through the requirements of Act 6 and Act 91. But one of the requirements of Act 6 is that not more than $50 in legal fees and legal fees can be assessed on a mortgage account before foreclosure is initiated, which we take to mean the filing of the complaint. So in the case you just mentioned, wouldn't Act 6 have prohibited the charging of $1,200+ to the account?
Yes.
At that stage?
Yes, it did. And in fact, one of our defenses in defending the foreclosure was that their position was that the file was sent to foreclosure counsel before they received the money that fully reinstated the loan. But it was clear that the loan was, it was a day, they say it was a day. Like, day one they sent it to foreclosure counsel, day two they got the money, and then day, 6 or 7 is when the complaint was actually filed.
So the money got there before the complaint was filed?
Well, my argument is...
So they only had a right to $50?
That's right. And that was my defense. And I said, I can't, even if you're entitled to a day's worth of legal work from your counsel, it's $50, and my client would be willing to pay that $50 extra on top of whatever you already have. But they took the position that they were entitled to the full amount because the file was sent to foreclosure counsel prior to having received the money.
Okay. Important to keep in mind the provisions of Act 6 regarding what fees can be assessed against an account prior to and then after foreclosure begins. And again, Dan's going to talk about that in detail.
The other servicing problem that I've run into, and maybe this isn't a broad servicing problem, but it's a problem, I guess, somewhat related to Act 6, and it may not necessarily be applicable to situations that you have under the purposes of this grant, but I think there might be some help here. And that is, I have persistently been told different numbers between what the mortgage company says they're due for legal fees and what the lawyer representing the mortgage company says that they've billed for legal fees. And for instance, the most recent example of this is that we had a loan modification that was a really, really good loan modification for my client. This is post-litigation, but it had $3,900 in legal fees that were added to it that were supposed to be wrapped up into the arrears. And I said, this is an absurd amount of legal fees. All that was done was a complaint was filed. When I talked to the attorney representing the mortgage company, they said, no. We submitted to them $1,200 in legal fees, and we'd be willing to reduce it to $750 if that's what gets this whole thing done, and we'll talk to our client about this. And back and forth, the mortgage company keeps saying $3,900, the lawyer says $750, and I got on a 3-way conference call with all of them, and what the servicer kept saying is you have to submit it through some, I don't know, code word, some system that they submit mortgage, that they submit fee applications for, requests for fees for. And the attorney representing the mortgage company said, I did, I kept doing this. And they wouldn't, the servicer took the position that we go by the numbers that are on our system, not by what someone's telling us over the telephone. And so it was incredibly, incredibly frustrating. And I can imagine that this would also arise, again, in the context of a post-bankruptcy, a post-discharge situation where your client gets one of those Act 91 or Act 6 delinquency notices that show they show legal fees, and when you talk to the bankruptcy attorney or the bankruptcy attorney's department, they say, well, we didn't bill that much. And when you talk to the servicer, they say, yes, you did. And so it's a problem, and I don't have any great way to have you resolve the problem. It strikes me as incredibly odd that if the lawyer's saying, no, you don't need to pay me that much, that the client would insist on paying them that much. But I guess if they can get it out of the other end, maybe that's why they do it. But keep that in mind, that these legal fees might not be matching up, and you really even sometimes have to go to that level of, negotiating between the two parties that should be on the same side of the fence.